actually want to make a comment, and I would like you to make a rejoinder or a comment over my comment, because I actually feel very well when you stress this idea of dynamics, not only the issue, but the dynamics in the judiciary relation vis-a-vis the other branches of government, the interplay of the other branches of government. Because, to my knowledge, the problem is very difficult to tackle the problem if we just focus on one particular issue and one particular institution. And to my knowledge, it looks like that in several of our countries, the problem is more complex. It doesn't work, separation of power. This idea that was brought yesterday about representativity, about responsiveness, about accountability within, the state, it doesn't work, simply. Even though if we can choose a wonderful system, we provide tools to make them accountable, and we have no goodwill in order to choose the proper person to have office or to be a judge, I think we still have these kind of problems because of the dynamics. My guess is that, particularly in my country, there are some exceptions like Colombia, and of course some countries are doing better. I wonder, perhaps you share my grasp that it is all the system that it is not working well. I mean, we have untamed executives, the problem of hyper-presidentialism that of course impinge upon the selection of the judges. We have, I would say, reckless representatives who do not pay attention on what's going on, and they do not choose according to the candidates, the nominee skills. And we also have judges that are disciplined, subordinated, or otherwise unfettered judges. So to wrap it all, I would say that my guess is that we should focus rather in a broader scope, because it is not just a matter to choosing the proper incentives in order to have in a timeline, a T1, the right guy in the bench. Because you can have the right guy in the bench, but working, in a very bad system.
Yes. My congratulations to both panelists, and I would like to make 3 short comments or questions. First, to Professor Landa, I know that in Peru you have problems, as we do have in Spain, because sometimes constitutional judges are not renewed in time, so they remain in office until the new judges are elected. I know there has been demonstrations in Peru, and there has been not demonstrations in Madrid, but sometimes a judge can remain in office 1 year, 2, or even 3. Do you think this can infringe the appearance of independence? So it is fair that a judge can write a judgment when it's more than a year, more than a reasonable period in a prorogatio, this technique we took from Italy that I'm afraid it doesn't work because the general rule has become the exception, the prorogatio. To my colleague, Serna, I've been in Mexico a couple of days before coming here. That's why I am so tired. I know that you are very worried because for the first time you don't have hyper-presidentialism, but a president elected by absolute majority, and both houses too, because yours is not the American system with 2 stops, 2 check and balances. So the president has the absolute majority and says that he wants to abolish the prerogatives or the privilege of the Supreme Court. I don't know if he's talking about the executive powers of the court or his huge budget. I would like you to make a reflection about this future conflict on the independence of the court by the new presidents. And to both panelists, do you think it's important? There is a jurisprudence that we all know, Latin Americans and Spaniards, but probably is not so well known outside of the region, of the Inter-American Court in the case of the Peruvian constitutional judges and several cases related with Venezuela, where many, Verón Trujillo and some others, were removed from office by the executive. Do you think it's important, this jurisprudence, this case law related with independence of the judicial that cannot be removed by the executive? Yeah.
On the, say, the subterranean or underground procedures that take place, because we mentioned yesterday, some people were jokingly said, you don't have to know the law, you have to know the law minister. So this is the situation when the law minister plays a predominant role in the appointments. But when there is a political body like parliament that has to either confirm or elect, what is the procedure? For example, do the judges lobby? Do they go to parliament to meet the main leaders of the parties to enlist their support? Do they buy the services of PR agencies to get nice reports in the newspapers? And do they have a lobby in a professional way? Because there are lobbyists in modern times. If you not want to get something done, you have to pay a lot of money. So the lobbyist, you know, every corporation has a lobbyist to make sure that the regulations do not affect their business or benefit their business, depending on their strategy that they want to achieve. So the question is, okay, we have the format that is provided by the Constitution, but what is the practicalities of how you move as a judge to get either promotion or confirmation or nomination? And this would indicate to what extent, you know, the point you made, Professor Landa, about tell me who appointed you and I'll tell you how you rule. It depends on what is the exact procedure that takes place. And it will be interesting to hear what both in Mexico and in your country, Peru, how does it take place? How does it operate?
I want to make some reflection about the context of the issue and dynamic of the nomination and appointment of the judges, because it's very important, the model not only of the constitutional provision but also in the political regime. For example, in Latin America, the presidentialism is very strong. But in nomination of the judges, in the Peru case, there has been a change since the Constitution of 1993, because create an autonomous organism, National Council of Justice, to nominate the candidate to the judges, the Supreme Court, and with public concourse, with requirement that I told in the introduction, but that has not been enough to stop the influence of the political party, because there has been worse influence of the network of corruption. In this way, I think that the presidentialism is one part of the problem, but also in this age in Peru, there has been a powerful movement of neoconservatives in the Congress, that they gain the Congress, the opposition in the Congress control the majority, and is developing measure of control like an impeachment against the president, against the ministers, another membership. But the problem of the corruption is not only a product of the judicial system, but also linked to the entrepreneur and the parties. It being linked to the majority of the party, the Fujimori party and the APRA party. No? In this way, the actual president of Peru is not to negotiate with the party or with the society, but appeal with the referendum of the constitutional referendum directly to the people. So the people is sovereignty, and when there is a crisis, could be the solution to improve the reform of the judicial system, creating another organism, no? More balanced, avoid the parties, and is a new say. So I think there is not only the negotiation in the arena of the parliament, of the political, but also appealing to the people, to her. And the people in the survey opinion is against the corruption. They wanted to separate the judges or the politicians or the party that are against the values of the democracy. And that's important because our weak democracy, we have to strengthen it with the participation directly of the people, I think. So could be, it's maybe sound a little populist, but I think that we can remember the sentence of the administration of justice is founded in the will of the people. No? The people is the fount of the the justice administration. So, in the other way with about when the turn of the Constitutional Court in the case that you asked me is Peru is very short term, 5 years, no? And when the party is very weak, the system party, there is no consensus enough to achieve a two-thirds majority of the vote of the Congress to renew in the term of the 5 years. So there has been this effect in Peru and Spain and other cases when delay the new nomination because there is no consensus or nullify the designation like I told you in 2003 and 2007. And while this delay of the change of the charges could be interpreted as subordinating or affecting the independence, I think that one part, yes, when there is, in Peru, look for the nominate of the judges of the Constitutional Court is in the same time of renewal of the Congress. So the majority passed can to the possibility to nominate with concordance of the position some number of judges, but with the new parliament, the new parliament has not the majority in the Constitutional Court. So there is not exactly, yes. That means that the Constitutional Court in the last decade is a corporation of control of the majority with more strong, weak possibilities, but it's not in the same way of the nomination of the Congress. For example, the next year, recently, this majority of the Congress elected 2016 could be changed 6 judges of 7 of the Constitutional Court and will change maybe the composition of the decisions of the political interpretation of the Constitution. No? That's me. So there is no correspondence. And in this way, I think the new renewed immediately in the 5 years, it could be in some one case an opportunity to control of the Congress, but in other ways could be individual subordinate to political because the judges when cannot to get out is like a chain, you know? Is in jail because they want to get out and he cannot because he has to wait another decision of the Congress. So there is 2 interpretations, not only that the independence is lost, but sometimes the independence can maintain with a Congress that has not renewed. And finally, okay, the Inter-American Human Rights Convention has case about related to independence, judicial independence, in the Venezuela, and also in Ecuador when the Supreme Court and the Constitutional Court was closed, no, in 2004, no. And I think there is, in the case of Peru also, with judges of the Constitutional Court was expected by the Fujimori regime, and they was renewed the term with the democratic process in Peru and the decision of the Human Rights Court. No? In this way, I think that there is a guideline of the Inter-American Human Rights Court that it's an instrument very important to require to defend, to protect, no, the objective independence of the organ, but it defend also the independent subjective of each judge when it's removed. No? And finally, how in my experience, like a former constitutional judge, no, I was nominated by the party of the government in this moment, no, and I was submit a commission of the Congress in a public hearing about the question of the many matters of the juridical and political, no, issues vinculated to the protection of the human rights or the interpretation of the treaties, no, in several hard case, no, potential, no. And there has been a curriculum, not only the interview of politicians, but also this examination finally has a record that is present to the plenary of the Congress, but the Congress can to select not only the first, maybe the 10th position, but I was in the first, no? But in the other case was selected there has been 2 places and the 8th position was selected because there has been interest to this judge not to be incorporated to the Constitutional Court. So there is a mix in this age, no, 2004, no, to elect with the professional experience, but also politician experience. No? It was in the middle of the democratic transition, no, enforcing and improving values democratic. But now we are in a reverse process with the majority in the Congress, so we have to expect which is the rule that they use the next year. Thank you.
Thank you, Cesar, for your long answer, because you gave me time to think what I'm going to say. Pablo, as I understood your question or your comment, you are suggesting to have complex perspectives, integral perspectives, trying to give explanations to very complex phenomena. And yes, if we want to explain this increased judicial independence that has indeed been happening in Mexico, thinking of the Supreme Court of Justice, we have to explain it in very complex terms. It's not just a matter of a constitutional reform. Yes, it's a constitutional reform, but there are many other factors. As I mentioned in my presentation, the context, the general political context is the transition towards democracy. This is a general term. What is a transition towards democracy? There were pressures from below, very powerful pressures from civil society, demanding democracy, demanding political rights, demanding institutions for the protection of political rights, and not only of political rights, but of all rights. So those were internal pressures from civil society. But then there were other external, there were economic pressures and external pressures. Economic pressures, we changed the economic model in the 1990s. And we started this road in the construction of to simplify things, a neoliberal economic model. And one of the requirements of the new economic model was a strong judiciary to protect property and to protect contracts and to protect commercial transactions. It was within the logic of the new model, there was a need of strong courts. But then you have to add the economic integration with the United States the commercial integration with the United States and with Canada, the now extinct NAFTA. NAFTA required a huge amount of legislative changes in Mexico's legal system, and it also required the strengthening of certain institutions that were key for the functioning of the integration process with the United States and with Canada. One of those institutions was, or were, the judiciary in general, and particularly the Supreme Court. So yes, it's been a very complex process that has to be explained in those terms. The president-elect and courts, there is going to be a new government starting the 1st of December of this year. Andrés Manuel López Obrador. Why did he win the election? He is like an outsider. No? He won against the traditional parties. He was part of the traditional parties, but then he formed his own party, and he beat the traditional parties that have ruled Mexico for the last 30 years. Why did he win the election? There are many reasons why he won, but some of the key proposals of his campaign was the reduction of the tremendously high salaries of the high federal bureaucracy. That was one of his most important proposals. The other of his proposals was to tackle corruption. But all his campaign was, he was saying, well, if I get to power, I will reduce the salaries of all the federal public servants, including the salaries of Supreme Court justices. You don't know this, you don't have to know this, but in Mexico, Supreme Court justices win or earn tremendously high salaries, disproportionately high salaries. So the problem is that the Constitution says that the salaries of Supreme Court justices cannot be reduced during the time of them being in office. So what is going to happen? There might be a constitutional reform on this to allow the possibility of reducing the salaries of justices. And not only disproportional or tremendously high salaries, also there is a problem of nepotism. Yesterday I heard that in India there is a sort of similar problem. Well, we have a very, very important problem with nepotism within the federal power, both at the federal, within the judiciary, both at the federal level and at the state levels. With entire families who are judges or form part of the structure of the courts. Then, well, Cesar already said something about the importance of the Inter-American Court of Human Rights. Yesterday, I was surprised when the justice of the Indian Supreme Court said, when we asked him, or someone asked him, maybe it was you, Pablo, if the Indian court looked at other courts or at other decisions of other courts when making their decisions, and when he mentioned the Inter-American Court, I was surprised, but the court has increased its importance not only at the regional level but also at an international level. I informed this immediately to the president of the Inter-American Court, who happens to be a colleague of mine at the Institute of Legal Studies, and he was very happy to learn this. And indeed, in the case of Mexico, after having a period of resistance of the Supreme Court, a sort of nationalist attitude towards the influence of the Inter-American Court of Human Rights, now there is a period of acceptance and a period of dialogue between the Mexican court and the Inter-American Court. And the Mexican court has changed some of its traditional understandings of parts of Mexican constitution to put them in line with the interpretation or the decisions of the Inter-American Court. Or there have been, and I'm not talking about the Supreme Court, but talking about the power to reform the Constitution, there have been constitutional reforms putting the Mexican Constitution in line with the standards of the Inter-American Court. In the field, for example, of the jurisdiction towards the military, fuero militar. And then the underground procedures addressed by Professor Shimon. Is there lobbying with the president? Yes, there is lobbying with the president. Probably not directly with the president, but with people very, very close to the president. First, to get into the three-name list. And once in the three-name list, yes, there is lobby with the Senate, and yes, directly with the senators. And what's the result of this lobbying? Well, they don't hire lobbying firms, but they use, yes, but they reach the senators through different mechanisms. They negotiate, and the result depends on the correlation of forces within the Senate. The correlation of forces within the Senate has changed over the years. There was a time when the president had more than the two-thirds majority that is required to get someone into the court. Then there was another time in which no party had a majority, or not even an absolute majority within the Senate, so there had to be a lot of negotiation and compromise. And now one party has the absolute majority, but it doesn't have the two-thirds majority to neither to reform the Constitution nor to put someone as a justice of the Supreme Court. Another underground procedure that should be mentioned, addressing your curiosity, is this. To solve certain kind of cases, the court sits en banc, the 11 justices. In other kind of cases, it sits in chambers, chamber 1 and chamber 2. The first chamber leads with civil and criminal cases. The second chamber deals with administrative and labor cases. And in administrative cases, tax matters are included. And in Mexico, it's possible to challenge tax laws, generally supported, of course, by the Ministry of Treasury, for being unconstitutional. So an underground procedure is that the powerful Ministry of the Treasury always tries to have one or two or more justices that come from the Ministry of Treasury. Right now, of the 5 justices in the second chamber, 2 worked for many years in the Ministry of the Treasury. That's an underground procedure. Thanks.
So I wanted to ask both of you, as you consider constitutional reform of appointment processes in your countries, what are the comparative influences that are typically taken into account? Which other countries do you look to? Specifically, is the Indian model discussed? And if not, why not?
Follow up from what Adrian said. I think Jose Maria, you made quite clear that, I mean, all the models, you propose really some interesting institutional designs, but they all land up with the Senate at the end of the day, right, in your model. And as you just answered to Professor Shetrit, that has a lot of down consequences. It leads to a whole political process, which is arguably very problematic for judges. So why not look to the Judicial Services Commission model of in African countries and I think the UK now and others?
Just now I heard both of you introduce the nominating procedure of the judge. Just refer to the hearing. I just want to know this hearing just inside or outside of the parliament. Okay.
Other model of appointed judges, maybe that could be interesting, is in Latin America a new wave of the neo-constitutionalism, no? That was supporting Bolivia, for example, more than Ecuador, another country, because they elect directly with the popular vote, no? The member of the Supreme Court, judge, and the Constitutional Court, no? They criticize the constitutional model representative democracy because doesn't express the voluntary of the people, no? So in the new constitution of Bolivia, with the advice of the Spanish colleagues from Valencia, no, Viciano, no, that support the new constitution of Venezuela, in Bolivia incorporate the right of the people to directly, no, elect the supreme judges, yes, yes. But there has been one trick, no, because the candidate has to registrate in the parliament where there's a commission to select the candidates. No? In this commission, colleagues from Bolivia, the constitutionalists, told me that there has been a political classification, no, for to avoid or not or allow to candidate someone, professors or judges, no, according to the will of the government. No? This is the model of the Evo Morales constitution that he is re-elected for terms, no? And he's following, no? Re-electing. No? So in the practical, when has been elected with a few votes, no, in the elections, because the people are not accustomed to decide who will be the judge, no, in the Supreme Court, no, which is the proposed, no, that he offered to the citizen in the justice, no. There has been few participation in the election of the judge, but there has been enough the vote, so they have been elected. No? And in my experience, when I visited Bolivia, invited by the Constitutional Court, no, there has been minority of the judges elected by the political system, because there has been not only majority, but also minority. But this minority of judges elected by the election, national election, was at the end removed, no, in the Constitutional Court. That means this popular election, political election, is no guarantee of the pluralism, no, of the election of the judges with the popular vote. No, it's a way. No? So I think that there is different kind of model: the democratic directly, the corporation with representative of institution, no, of the political system. But in any way, I think, as I explained in my presentation, most important is the quality of the candidate, no, or the compromise of the aim, the most important force in the democratic process to respect this election. No? In this way, I can say that the political model, yes, is the most transparent way, because in the experience in Peru, when we create the national council to select the candidate, the party was not directly present in this election, but there was in the grassroots, no? The lobbies of the party was working beside the decision taking for independence organs. No? So I think I preferred a political model directly, but with someone requirement to transparent and pact for the justice, for example, where the methods for the designation of the judge was not only like in Italy, lottizzazione, you know, some judges for one party and one judge for the other party. But it's impossible to break this rule, but I think that could be more transparency. With the transparency in the public opinion, it's a control very strong, no, for the compromise outside the eye of the people, no? And that's limit the party at least. No? And the hearing, no? The hearing is it's not, the hearing is a matter in Peru when designed the judges of the Constitutional Court, because there has been debate where the Congress cannot make a television immediately transmission of the hearing. They want only registrate, put in a file when the people went to check the debate. You know? So there is no immediate control, and the NGOs and the independents organized want to promote more debate, public debate for the candidates. And now the next year, each year the Congress are changing also the way of the hearing. No? More clauses or no clauses, and but at the end, I think that it's the way, not the best, but no bad, no, in the possibility of the citizen to compromise with the candidate and qualify and the question of the party to select the best candidate in the academic way, and then they take the political decision. No? Finally, in my case, I was, as I said, nominated by the government. So in this way, I was Vice Minister, Deputy Minister Justice, no? And, but also, the best rule that I learned is the principle of the ingratitude. No? So that is the first rule, very important when any judge achieves on a court. No? That's it. That's not mean that we can to say independence. That doesn't mean that cannot to rationality and proportionality consider circumstance to decision, no? Because the tasks of the judges are not only involved in one case, no, individual, but also in the order, objective order, in the balance of the budget or in any way. No? I think it was my experience that it must to be also in a hearing submit to the candidate to know not only individual thing, but also like a subject, public subject decision.
Well, I'll try to address Adrian's and David's questions with a single comment. Why not look at other models? And you are right. We have had a very narrow discussion in terms that we are not examining other models for the appointment of justices. I have to say I was not aware of the existence of so many models to appoint judges. That's why I took note of what Professor Shitrit was explaining to us yesterday, the different models, predominant executive role, general elections or combined models, legislative elections, appointment by committees, special case of, I was taking notes with great interest. In fact, I have to make a report to my university when I go back to Mexico to explain what I learned here and what can be useful for the Mexican debate. So I will, of course, include this, but not only to my university. I will go to some people whom I know, who are close to decision makers, and I will tell them, well, why don't we widen the debate? We have always followed this. It's the American model. And if you think of it, at least theoretically speaking, the American model for appointment the appointment of judges makes some sense. No? The president represents the unity of the state. He's the head of the state. The Senate represents the diversity, unity and diversity. In a federal system, well, it makes sense, at least theoretically. But you're right, we should widen the discussion and examine the possibility of having a different model. This is going to be difficult because it implies changing the mental frame of mind of many scholars, of many politicians, but at least I think we should inform the debate with different ideas, and certainly what I have learned here will be I think, useful to enrich that debate.
So we can wind up. Before we wind up, some of my random thoughts in the light of what experiences which we have. So one of the things which I noticed in the presentation of Professor Sarna was that he was emphasizing on time limits. So far as Indian Memorandum of Procedure is considered, there is a time limit, but that is generally ignored because of the fact that generally time limits are not considered as binding part of Memorandum of Procedure. So the idea is this: how you look into all this, whether it will become binding, what will happen if it is not confirmed or rejected within the time limit. That is one of the things. And second, in the context of Peru, that is something which is very interesting, that you can address people for the purposes of having certain constitutional reform or judicial reforms. So far as the judicial reform coming as a kind of mandate from people is hugely problematic, because it goes back to the same idea that judges are supposed to do certain things which are unpopular, and that's why the power may be, or power that is, transfers those kind of decision to the judges, because political executive cannot take unpopular decision. So that is one of the problem which we'll have to address. But I'll thank you both for making such an excellent presentation, and to have the attention of the audience in a post-lunch session is truly remarkable. So let us have a big hand of applause.